President, on the first floor of the Federal Building in Amarillo, across the street from a grassy park and a few blocks away from the local minor league baseball stadium, is the United States District Courtroom for the Northern District of Texas. Presiding over that courtroom is a lifelong right-wing activist, a partisan, an ideologue, an anti-abortion zealot, who was handpicked by Donald Trump and the Federal Society to pretend to be impartial on the bench. And instead, what he's doing is delivering favorable rulings on the cases his fellow right-wing ideologues funnel his way. His name is Judge Matthew Kacsmaryk. He was confirmed in 2019 on a party line vote. In a matter of days, he's going to issue a ruling on a case so absurd and so meritless that it doesn't deserve a single breath of argument in his courtroom. The case is the so-called Alliance for Hippocratic Medicine versus U.S. Food and Drug Administration. If we allow it, Kacsmaryk's ruling could deal the next devastating blow to the right to privacy in America and the right of all women across the country to control their own bodies. Mr. President, not just in Texas, all 50 states, every single one. So this afternoon, I'm going to describe this dangerous new political scheme playing out in the courtroom. And Mr. President, I call this scheme court washing. And I'm going to talk about what the President and the Food and Drug Administration must do when this judge's ruling comes down. The lawsuit in Texas aims to undo the Food and Drug Administration's 2000 approval of a medication called mifepristone, one of the two drugs that's used in a medication abortion. The drug has a record of being very safe and effective. It's used in more than 50% of abortions nationwide. It's been on the market and used for this important treatment for 3 decades. Anyone who calls its safety into question is just ignoring the factual record. I've got a long history of working on policy relating to mifepristone. I was one of the first elected officials to advocate for its use in our country. In 1990, I chaired the first ever congressional hearing on mifepristone before the House Small Business Committee. But then, like today, right-wing extremists pulled out all the stops to keep the drug from being approved. They campaigned on the politics of fear, threatened lives, and just lied about the drug's safety. They even once deployed a small bomb at a conference where the chemist behind the medicine was scheduled to speak. Their efforts worked at first. The Food and Drug Administration imposed an import alert on the drug that hindered research on its uses outside abortion. I fought that import alert and introduced the bill to remove the restriction. The Food and Drug Administration finally approved the drug in 2000. My advocacy around this issue and the drug has never been based on some political agenda, but just science and fact. So let's look at the facts, not the fiction you hear from the plaintiffs in the case. It's a fact that this medication is key to ensuring fundamental rights, including the right to privacy and the right to make your own reproductive choices. Medication abortions allow for women to end a pregnancy at home in a way that's safe. It's a fact that mifepristone has fewer complications than Tylenol. A wealth of evidence demonstrates the drug's safety and effectiveness. It's a fact, Mr. President, that Republicans on the Supreme Court have said the issue of abortion should be returned to the states, that the country shouldn't have a one-size-fits-all policy on this issue. So the question to ask is, how did it become possible for one single judge in Texas to be on the verge of blocking access to a drug that a duly authorized federal agency has said is safe for over 20 years, and yet that judge could very soon block access to the drug nationwide? To answer that, it's appropriate to tell a little history. Congress long ago empowered the Food and Drug Administration, made up of scientists, to approve or disapprove the use of new drugs, not the states, and certainly not activist judges. The Food and Drug Administration approved mifepristone 23 years ago. For those looking to challenge that approval, a little late. The statute of limits allows challenges to food and drug procedures for 6 years. If that wasn't clear enough, Congress cemented its approval again in 2007 as part of an amendment to the Food and Drug Act. Any drug previously approved by the agency was deemed to be in compliance with new rules governing the Food and Drug Administration. Mifepristone is covered by that amendment made by the legislative branch. There is no reasonable argument to the contrary. Nevertheless, the plaintiffs in this case want Judge Kaczmarek to reach back through time, Mr. President, bust through the statute of limits and congressional intent, and toss out the FDA's legal approval. Furthermore, the plaintiffs in the case have no standing to bring the suit. To establish standing, a plaintiff has to show actual harm or injury to demonstrate a direct impact by the actions of the defendants. The plaintiffs are extreme anti-abortion groups and their doctors. Here is the absurd claim they're putting forward. They argue, defying science and fact, that some unknown future patient may take mifepristone, experience a highly unlikely side effect, and then somehow find their way into one of their exam rooms for treatment. If a standing claim that ridiculous and overly broad passes muster, then I just think it's time to rip up the legal textbooks in America and start over. That would mean that anybody could wander into federal court and seek relief against anybody based on wild, dreamed-up scenarios, hypothesizing that somehow, some way, somebody might be injured in the future. Legal logic be damned. The plaintiffs know that Judge Kaczmarek is sure not going to let pesky obstacles like precedent or science or standing get in the way of the agenda that they share. That's because Donald Trump and conservative activists planted him to be on that bench in the Amarillo courtroom right now. They know he has spent his whole career fighting shoulder to shoulder with them against LGBTQ equality, abortion, contraception. He is there, Mr. President, for one reason, and I call it court washing. In the court washing scheme, the judge has the role of giving the appearance of judicial legitimacy to the outcomes that the right-wing activists know they're going to get as soon as their cases show up on his docket. In the few years that Judge Kaczmarek has been on the federal district court, he has earned the title of the most lawless judge in America. It's tough to earn that kind of infamy in a short time, but his rulings have justified it. He has issued constitutionally dubious and extraordinarily contentious opinions. He's defied precedent on protecting LGBTQ employees and attacked the right to contraception by restricting minors' access to it. Now he's got a case on access to abortion medication that is directly intertwined with the rights of privacy and choice. The plaintiffs, who have no legitimate standing, have handpicked him to hear this case that has no merit because they know what they're going to get with Judge Kaczmarek. They've gone to him for court washing. The plaintiffs want mifepristone outlawed in every single state in America. And with this judge, they found a way to make it happen. Because of how judges in this federal district in Texas are assigned, the plaintiffs could use a procedural loophole and hotwire the judicial branch. They could ensure Kaczmarek was the only judge who'd get the case. No shot of it getting assigned to anybody else. To make this more frightening, if and when Kaczmarek tosses out FDA approval, Americans can't count on the appellate courts to step in and do what's right, do what's constitutional. The appeal would land at the activist Fifth Circuit Court of Appeals. This is the same court that allowed Texas Bill SB 8, effectively an abortion ban, to go into effect before the Supreme Court ruled on Dobbs. From there, any appeal would presumably head to the very same Republican majority on the Supreme Court that overturned Roe. The Roberts Court doesn't even wince at revoking constitutional rights and upending decades of precedent on legal grounds that are flimsy. By the way, at this point I want to note it's a fairly recent phenomenon that a single judge even had the authority to issue a nationwide injunction. Until 1976, three-judge courts were required to enjoin federal and state laws. Even after that, was no longer required. It was relatively uncommon until about a decade ago to see federal laws and policies blocked in their entirety by the ruling of one district court judge. Now, it's true that these type of injunctions have been used against both Democratic and Republican administrations. The difference here is that the appellate courts, and particularly the Supreme Court, are aiding these polarization efforts, but only for one side. So some numbers. On 41 occasions, the Trump administration asked the Supreme Court to put on hold an adverse lower court ruling for the duration of the government's appeal. In 28 of those cases, the Supreme Court granted the Trump administration relief. In comparison, the Biden administration has sought emergency relief from the Supreme Court 9 times. The Supreme Court's granted it on only 2 occasions. And incredibly, the court has granted emergency relief against the Biden administration 4 times, something that didn't happen during the lawless days of the Trump administration. So what does that mean for the case in Texas? Well, if and when Judge Kaczmarek issues the ruling that he was hand-picked to deliver, Mr. President, the court washing is on. The Fifth Circuit, which has little respect for precedent, will almost certainly uphold his ruling. Then the Roberts Court will almost certainly leave the ruling in place through the long and arduous appellate process. All the while, millions of women will suffer grave danger. The harm that will result from this decision can't be overstated. Cut off from care they need, Mr. President, women will die. While this wouldn't be the first time a judicial decision has caused irreparable harm, this case is particularly offensive. It'll come from a lawless judge, picked by the litigants with no standing to bring a case that should be barred by the statute of limits and has absolutely no merit. So I'm here, Mr. President, because to sum it all up, Americans and their leaders must look at circumstances like this and say, enough. Not, we'll see what Congress might do, how the appeals process is going to play out. What's needed now is to just say, enough. The power of the judiciary begins and ends with its legitimacy in the eyes of the public. It doesn't have the military backing of the executive branch or Congress powers of the purse. A judge's ruling stands because elected leaders and citizens have agreed that abiding by them is right and necessary. to uphold the rule of law. It's part of our social contract. But the judiciary must uphold its end, the social contract, too. It's got to follow the rule of law and earn the confidence of the American people every single day. Recently, that confidence has eroded. No secret why. Look at the Dobbs decision overturning Roe. Look at what's happening in Texas now. Parts of the judiciary seem to have morphed into a mob of MAGA extremists conspiring with and willing to do the bidding of every right-wing group or former president that appears before it, no matter the cost to life and liberty. The awful reality from the moment this case landed in front of Judge Kaczmarek, it's been a rigged game, illegitimate. The case is an affront to the Constitution and to the rule of law in our country. So here's what must happen if and when Judge Kaczmarek issues his nationwide injunction. Nationwide! All this business that the states have rights, This has nationwide implications to halt access to mifepristone. And my view is President Biden and the Food and Drug Administration must ignore a nationwide injunction from Judge Kaczmarek. Don't give in to the court washing. Protect the fundamental rights and well-being of all women in America. The Food and Drug Administration ought to go on just as it has for the last 23 years since it first approved mifepristone. The Food and Drug Administration needs to keep this medication on the market without interruption, regardless of what this ruling says. Doctors and pharmacies should go about their jobs like nothing has changed. American leaders who care about the right to privacy and the lives of women in this country must not let an illegitimate ruling in this case stand. It's just not possible to hide from this fight any longer. Let the right-wing extremists stand up and explain why they lied, Mr. President, to the people of this country when they said the Dobbs case was just going to be about returning abortion law to the states. In the face of a court-washing strategy whose outcome is almost certainly predetermined, we can't possibly say we're just going to wait around and see what happens with Congress and the appeals process. Too much is at stake, and this case will not be in the hands of public servants who are staying true to their oaths of office. Women in America need to know that they're not going to be cut off from their privacy rights and the care that they seek and they have a legal right to obtain. Not for a year, not for a month, not for a day. If that's what the ruling would do, the answer is to ignore it, at least until there's a final ruling on the underlying matter by the Supreme Court. Let me close with this, Mr. President and colleagues. I don't say this lightly. I have never said anything quite like this before. I believe in the three branches of government and respect the role of the judicial branch. I've had the honor to represent Oregon in the United States Congress for more than 40 years. First in the House, for the last 27 years in the Senate. I've raised my hand, taken an oath to uphold the Constitution of the United States. I do not intend to dishonor that oath, which is why I'm standing here this afternoon. This judge is not upholding the oath he took. He's not adhering to the Constitution. He is stomping all over the privacy rights of millions of women in this country and ignoring the rule of law, and something needs to be done about it. Let me close by saying this wouldn't be the first time a political leader or elected official has called on others to ignore a court ruling. Abraham Lincoln did it after the Supreme Court issued the historically egregious Dred Scott ruling, which held that black people could never be citizens of the United States. Lincoln called the decision erroneous, an abomination. He pointed to the partisan bias in the opinion, that it was based on assumed historical facts which weren't true. that it was one opinion that couldn't be considered precedent. Sound kind of familiar, Mr. President? Lincoln's directive in response to the case was that it's the constitutional duty of elected officials to resist unconstitutional decisions of the courts, even the Supreme Court, if the rulings will harm the nation and its people. Now, Mr. President, these cases are obviously different with very different circumstances, and nothing compares with the horrors of slavery. Nevertheless, these cases do have something in common. It's a question of the advancement of rights versus the deprivation of rights. The advancement of individual rights is at the core of our national character and history. This case before Judge Kaczmarek rejects that. It is clearly part of an effort to backtrack on a century of progress for American women and deprive them of fundamental rights: the right to privacy, the right to control their own bodies, and stemming from that, the right to live and work and participate in American life fully and equally. That will be the outcome if the court-washing strategy succeeds. If Judge Kaczmarek can violate his oath to deliver the outcome his fellow right-wing activists are after, if the Fifth Circuit and Supreme Court bless such a ruling as legitimate, we are going to see an affront to the Constitution. As Lincoln told his fellow Americans, the Supreme Court is not the Constitution. Neither is Judge Kaczmarek. The Constitution and the rights it affords American women are what this country must defend. I'm here to say enough and defend it. President, I yield the floor and note the absence of a quorum.